Namaskara, good evening, and welcome to today's BIC stream session, Who's on Trial Here? A deep dive into the Tarun Tejpal verdict. The judgment acquitting journalist Tarun Tejpal, handed down by a trial court on 21st May 2021, has far reaching implications for justice in cases of sexual assault in India. State versus Tarunjit Tejpal is one of the first prominent cases to be tried and prosecuted under the Criminal Law Amendment Act 2013, an outcome of decades of struggle by the country's women's rights movement for an expansion of the legal definitions of the acts that constitute rape and the contexts in which consent is given. Today's session will include highlights of a detailed critique of the judgment by the Network of Women in Media India. The discussion will examine issues of consent, trial processes, data privacy, and also the enduring ubiquitous gender based rights violations in Indian newsrooms, which have not yet evolved adequate institutional redress. On today's panel, we have Anna Vetticad, journalist, film critic, and author, Jayna Kothari, senior advocate and co-founder of CLPR, Vakasha Sachdev, associate editor, The Quint, uh, Jhuma Sen, associate professor, Jindal Global Law School. And the session is moderated by Laxmi Murthy, co-founder of Network of Women in Media India. This session is in collaboration with the Network of Women in Media India and the Center for Law and Policy Research. The bios of all the speakers will appear in the chat box, which is at the bottom of your Zoom screen. Through the session, please feel free to use the Q&A box, which is also at the bottom of your Zoom screen next to the chat box, to post any questions, observations, or comments to the speakers. And with that, I hand it over to Lakshmi.
Thank you, Lekha, and thank you, BIC, for providing this wonderful platform. And good evening, everyone. Welcome to everyone to what promises to be a really exciting and stimulating evening. It's not like this case has not been discussed threadbare, but the panelists we have here today, introduced already by Lekha, bring to it extremely specific insights from their own locations, their own expertise as journalists, as lawyers, as academicians, and all of them very, very invested in women's rights and justice. I just want to start with an anecdote. Beginning in the late 1970s, in 79 and 1980, when as a young college student, I witnessed the nationwide outrage about what was then called the Mathura case, where an Adivasi, a teenager, a minor girl, had been gang raped by policemen in the police station in Maharashtra. That case, of course, was the impetus for a nationwide movement against rape, for law reform, and for very public discussions about rape itself. But what is surprising and almost shocking and outrageous in a way is that male entitlement over women's bodies has hardly changed 40 years on. And what's even more shocking and even more outrageous is that judicial sentiment and mindset has changed little. The mindset that focuses more on a rape survivor's sexual history and past than issues of consent, and a mindset that's more worried about a perpetrator's reputation than the fact that a position of authority and power was abused. And this was actually a huge opportunity. It was one of the first prominent cases to be tried under the new amendment in 2013, the Criminal Law Amendment, where two of these crucial factors, one was the definition of rape itself, which went beyond vaginal penetration, and also bringing in categories of aggravated rape, which also looked at the position of authority of the perpetrator, the accused. This was an opportunity, and we shall proceed to see how whether this opportunity was used or misused or squandered, and what it really means for working women in general actually, working women and journalists in particular, because this is a question of a working woman, a working journalist, and the experiences that she had to undergo show lessons for a huge spectrum of issues. So, the format we are going to be following is that each of the panelists will speak for about 5 or 6 minutes, and then we have a round of interactions amongst the panelists and the moderator, after which we open it up to question and answers, which you can type into the Q&A box. It could be comments as well or questions addressed to specific panelists or in general. We'll take those after each of them have had their say. So let's get on with it. And Anna M.M. Vetticad, journalist and film critic, is our first speaker. So she will start off. So, Anna, who's on trial here?
Laxmi, as a member of the Network of Women in Media India, you know that the the question that was before us when we decided to launch into a critique of the Tarun Tejpal judgment was precisely this. This was an important case because it was the first high profile case that was being tried, as you mentioned, under the Criminal Law Amendment Act of 2013. And therefore, it was a huge opportunity because since it was high profile, it had served to educate people on aspects of the law that were not widely known. For instance, the fact that digital rape was now like in the statute books, and it did not require any discretion on the part of a judge, or the fact that it was clearly stated that what happened in this case in the law books was deemed rape. All of this was therefore there was a lot of hope because of this when this judgment was coming out, because there was so many purposes that could have been served in terms of awareness building and education of the public. What we got instead was a judgment, and this we've discussed in detail in the NWMI's critique, was a judgment that did a few things, like off the top of my head, I will say, A, the person put on trial was the survivor, not the accused. B, the definition of consent was completely confused in this case. And C, the arguments put forward within the judgment, in fact, mirrored the arguments of the defense. And the fact that the defendant, the fact that the accused in this case, Tarun Tejpal, had been flip-flopping from day one was not deemed relevant, but the survivor, every word, every sneeze, every cough, every moment of hesitation was scrutinized as though she was the criminal in this case, is the most striking aspect of this judgment. The fact that a young woman who had come forward with an accusation was put on trial in a way that decades of women's rights activism had sought to end. And the women's rights movement thought that at least with the new laws coming in, there might be hope of it ending. It was completely lost because what we saw in the judgment was the trial of the survivor and not the trial of the accused. A simple thing that would help laypersons understand this. There were three letters, mails that were sent by Tarun Tejpal. There was one that he described as an informal apology, which he sent directly to the survivor. There was another he described as a formal apology. Now, in the formal apology, and I'm going to read out a portion of it because although it is in the public realm, people may have forgotten, and it is so striking and it is so shocking that this was not deemed as an admission of guilt by the judgment. In his formal apology, he writes, "It wrenches me beyond describing, therefore, to accept that I have violated the long-standing relationship of trust and respect between us, and I apologize unconditionally for the shameful lapse of judgment that led me to attempt a sexual liaison with you on two occasions, on 7th November and 8th November 2013, despite your clear reluctance that you did not want such attention from me," unquote. Despite this, ultimately in the judgment, it has been deemed that the emails that were sent, these two, the formal and informal apology, and a later mail that Tarun Tejpal sent to the managing editor of Tehelka, Jhuma Chaudhary, which she forwarded to the entire staff, that these were actually sent under pressure, and that the pressure was brought to bear by the survivor on the managing editor of Tehelka, and by extension on the accused, the claim of the judgment being that the survivor had said that the matter would come to an end if she could get a formal apology. Now, what is the definition of pressure here? The power equation, as the law has discussed it, this is a young woman who is in the beginning of her career. She is a junior to both Jhuma Chaudhary and Tarun Tejpal. He is the founder and promoter and editor in chief of Tehelka, which is where she works. He's the senior most person in her organization, and he is someone who is extremely influential in the media profession and he can cause great harm to her career if he chooses to do so. This person was deemed by the judge in the case to have come under pressure from this young journalist who was just starting out in her career. Even beyond, beyond the statute books, just as a lay person, if you have not read the law, just from common sense, how does this logically work? But of course, but of course, one doesn't have to rely on pure common sense, because the law itself and the admissions by the accused, and over and above that, an admission made in the judgment itself establishes that there was a power differential and that Tarun Tejpal was in a position of power over this young woman. I'm going to read out another portion of the formal apology, in which Tarun Tejpal himself wrote to her, "I acknowledge that there is an inherent disbalance of power in my position as editor-in-chief and you as an employee of the Tehelka, and there is absolutely no ground or circumstance in which I should have violated the propriety and trust embedded in that relationship," unquote. And Laxmi, the judgment itself notes, quote, "It is therefore proved that the accused was a person in a position of trust or authority towards the prosecutress and was in a position of control or dominance over the prosecutress," unquote. So, having acknowledged that the accused was in a position of power over the survivor, the judgment then goes on to claim that she brought pressure to bear on him and on the managing editor, Jhuma Chaudhary, and permits an absolute slut shaming of this young woman throughout the trial. And as if that wasn't bad enough, a higher court gave him permission, access to a copy of her cell phone messages, which means he got access to lakhs of messages that she had sent over a long period of time. And the defense used that to slut shame her and put her and her character and her past and her relationships on trial, so that what he did, his flip-flopping, his behavior, even outside the lift, none of that was on trial. And his written apologies, not one, not two, but three, became irrelevant because the person on trial here was the survivor and not the accused. There's a lot more to say, of course, Laxmi, but I will speak more later.
Yeah, I'm sorry to have to cut you off, but we can come back to you. And you've absolutely led us into the next speaker, Jayna. Jayna will talk about what Anna mentioned about access to the survivor's cell phone records in what's being called a digital strip search. And this is, again, one of the most disturbing aspects of the whole evidence gathering and trial, because also she's a journalist and there are many privacy issues which have been violated here apart from her personal privacy. So we move on to Jayna and we'll come back to you, Anna, for more. Jayna?
Thank you, Lakshmi, and thank you, Anna, for just giving a great overview of the judgment. I'll just focus on 2 points. One is evidence, the way in which evidence was taken and appreciated, and I'd like to then kind of move on to what happens in sexual harassment cases. So I'll first look at evidence. So, while Anna spoke about how, what kind of how, the apology letters and admissions were kind of conveniently, taken to be, obtained under pressure, I'd like to focus on one aspect which perhaps in the Indian criminal justice system is less focused on. And I think we need to use this judgment to raise issues of concern around it. And that is what is commonly known as a digital strip search. A digital strip search is when you basically take all of a person's digital data, whether it is through a cell phone or through their computer disk or any other digital materials, and basically have access to all of it. And that enables you to literally digitally strip search a person, which is far beyond what the trial or the particular instance requires. Usually, in a case of discovery, I mean, I'm just again going on to a few legal terms. In a civil case, if you want some evidence relating to a particular issue which is at case, you have the right to ask the court for discovery of documents. So there's a certain transaction, you say, I want the party to produce documents relating to this transaction. In this case, what we find is that she is a complainant or a survivor. Her cell phone has been taken by the police. It's not that just her messages relating to what, we first ask ourselves, why would the prosecution you want her entire phone? Her prosecution should have, first of all, courts should have only given permission to use what was needed by the prosecution to prove her case. Secondly, the accused has access to her entire phone. No discernment is made by the court in giving complete access to her entire phone records to the accused. And so, what has happened is that all her messages and literally her life has been played out in the judgment and used by the defense to kind of build her loose character and to really kind of prove her as a liar. And the way the court kind of uses it, the court in fact uses, I mean, all of this kind of building up of her as a person who lies has actually been done only because of these messages. So the court says that, court reports her drinking episodes. She was drinking with friends. The propensity of the prosecutrix to have sexual conversations. So, that is kind of borne out, saying that, oh, she would have made these sexual flirtatious conversations with friends. She had intimate relationships with people, that she was lying. That she had spoken to senior lawyers and taken their advice on how to present her case. So all of this has been kind of culled out from the messages. And so here we need to really ask, does should the criminal law allow for this? And should law of should our evidentiary guidelines allow for it? And I just want to kind of give one brief example. In other countries, in other jurisdictions, the UK, I mean, I'm just referring specifically to the UK. In the UK, such digital strip searches, there's been a call to outlaw them, and there's been a great reluctance to use them. And courts are not, in fact, allowing such blanket use of digital material, because it's been found that if unrestricted access is provided, it is unlawful. It is usually discriminatory because it's used only in a selective way, mostly against women who complain of sexual assault. It's obtrusive, and this, in fact, has been one reason why a lot of survivors or victims of sexual assault do not want to come to court, because it's almost like saying that I have to give up and expose myself if I want an investigation. So I'd rather not do an investigation. And it makes people lose faith in the criminal justice system. And for many of these reasons, a kind of blanket digital access of evidence is likened to a digital strip search, and actually is not permitted in many jurisdictions. But we see how it played out in this case. And I do hope that at least one of these issues will become an issue of reform in criminal law and in on issues of evidence, especially on the Evidence Act. Another issue that the court used is that the court used Section 8 of the Indian Evidence Act, which talks about conduct. It says, in addition to even all her messages and whatever she said, the court said, oh, but look at the conduct of the victim, and the conduct shows uh, all of it, her consent, etc. And so we wonder where that conduct was built from, what was it that showed her conduct. So the court kind of relied quite elaborately on that. So that is about, really on the evidence issue. I'd like to take a couple of more minutes, if I have, to really look at what happened. I mean, this is ultimately, it was a case of sexual harassment at work. There were charges of sexual assault. There were charges of Section 354A, which is sexual harassment. And none of these charges, were found, and there was a complete acquittal. And so the reform on sexual harassment law included both a civil law, which is which requires that an ICC be set up at a workplace, and there's an inquiry into the incident of sexual harassment at work, and it also provides that you can proceed as a criminal offense. In this case, we find that there was no civil kind of inquiry into her complaint of sexual harassment. Tehelka didn't institute an ICC, so this complainant had no civil remedy. In fact, perhaps if the civil law and the ICC complaint had been registered and there was perhaps a finding, it could perhaps have helped the criminal trial as well, because there would have been perhaps, hopefully, a finding of harassment where the standards of proof are much lower and not as high as the standards of evidence in a criminal trial. But we find that none of that happened. Because that didn't happen, or one of the fallouts is that the criminal trial also resulted in an acquittal, though it is pending appeal. You find a situation where a woman who's gone through sexual harassment has no remedies in law. She's lost her criminal trial. She has no civil kind of remedy that played out, and I think we have to really talk about this as well. We've had such reform in the law, but we see in a glaring case like this, where there was, it's not just a comment or a verbal comment. This is physical sexual assault that happened at the workplace, and the law hasn't worked. So I'd
Yeah.
like to end here.
Yeah, thank you so much, Jayna. I think these are really important points, and particularly the point about the digital strip search. I mean, the past couple of days, we've all been like completely in upheaval about the Pegasus revelations. And we find that the complainant in the case against the Chief Justice, the then Chief Justice, Ranjan Gogoi, her and her family's phone was hacked into. I mean, what does this really mean for people, for women complaining about sexual harassment? I mean, your point about them feeling, reluctant to go to court because of not just verbal strips, which have been, a norm almost, where, the defense just sort of thinks nothing of absolutely stripping a complainant of any kind of dignity. This is just an added layer to the whole thing, and thank you for bringing that up. We now move on to Jhuma. Jhuma will speak also about the process of the trial, maybe in the next round. But I don't know if you want to pick that up, since Jayna did bring up about trial processes and consent as well. So, Jhuma.
Uh, Thank you, Laxmi. Both Anna and Jayna have presented a very incisive critique of State versus Tarunjit Tejpal. I would like to take this opportunity to speak a bit on the question of consent first, or rather about the twists and turns on the questions of consent in this case, and how one should examine this issue in light of the post 2013 amendment judgments that tend to walk that extra mile to misunderstand and misapply consent, and to perhaps also use this opportunity to think if consent alone remains a viable legal category to determine sexual violence. Now we know that the accused was here charged with committing rape under secondly of section 375, which is without her consent. And from a reading of the judgment, it appears that the rape accusation was denied simpliciter by the accused. It was completely denied. However, if you take a careful look at the contents of the documents, including WhatsApp messages and email correspondences, which is a matter of public record, and the responses by the accused under section 313 of the criminal procedure code, they all seem to they tend to suggest otherwise. So this becomes clear as daylight if one looks at the three letters that earlier Anna was talking about, which are publicly available. We know that a complaint was made by the woman, either the complainant, and after that happened, the accused sends her two emails. One is an informal apology and another is a formal apology. Now, this is followed by a third formal email by the accused to the managing director, which was subsequently forwarded by her to the editors and the bureau. Now, in these emails, the accused writes that they were playfully and flirtatiously talking about desire, sex, and that that it was in that flirtatious frivolous mood that encounter took place. He also writes that he had no idea that this encounter was even remotely non-consensual for his junior colleague. And in the formal mail subsequently, he goes on to apologize unconditionally for the shameful lapse of judgment. I'm just sort of quoting from that letter. And this shameful lapse of judgment led him to attempt what he says was a sexual liaison with the woman on two occasions, despite her clear reluctance that she did not want such attention from him. Now, any reasonable person will wonder that if this alleged incident is simply denied by the accused, then what are these apologies for? This is a very it's a reasonable question. So what does the accused mean when he speaks about an encounter, and what do these words non-consensual, impose, reading, misreading, playfully, flirtatiously, liaison and all that, what do they suggest, if not to imply that these that such encounters, what the word he uses, on the two nights did occur, and that the accused was under the impression that the same were founded on mutual consent. Now, this actually makes consent a core issue before the court, despite all these irreconcilable and contradictory claims by the accused. And one normally would expect that when there are these kinds of contradictory and irreconcilable claims, the trial court will scrutinize these claims and try to respond to questions which are before it. Primarily two questions. One is was there a sexual intercourse inside the lift? And if the same is answered in the affirmative, then the second question becomes that, was such sexual intercourse without consent? Now, from a plain reading of these letters and the WhatsApp messages, it is clear that something happened, in the lift. Now, the defense argues that there was no sexual encounter, but drunken banter before the accused and the complainant entered the lift, which resulted in those apology emails. And the court then performs this impressive judicial wordplay. If I had the time, I would read out from that excerpt from the judgment, where the court replaces sexual encounter with judicial banter. And not just that, while performing this exercise, the court allows the defense to introduce past sexual history of the complainant with an impressive sleight of hand. So far from scrutinizing all these corroborating pieces of evidence and subsequent conduct, the court allows these salacious inferences, which are gossips at best, to be drawn from the prosecutrix's supposed sexual encounter with a celebrity guest at the previous year's thing, and which is sourced, interestingly, which is sourced from the accused himself and another defense witness who was hardly an uninterested witness, because he was supposedly claimed to be an ex-boyfriend of the complainant. And then the court then starts scrutinizing the complainant's character by putting her on trial, by lifting that statutory prohibitions under section 53A, 155, 146 of the Indian Evidence Act. Now, what I want to actually draw attention to is that this judicial, I would refer this as a judicial flexibility to misread, misunderstand, and completely evade the issue of consent. This is actually not new. This judgment, but this judgment, it's not new, but this judgment represents how far courts are willing to go, to do that. So if you will remember that in Mahmood Farooqi, this was 2016 judgment, the Delhi High Court turned the definition of consent completely on its head by stating that a feeble no may mean yes. And there the court invented a defense of mistake of fact for rape. And mistake of fact, I'm sorry, I'm getting into legalese, but mistake of fact is a defense to negate the mens rea of the accused, the criminal culpability of the accused. But there is no mens rea requirement for rape, which is sexual intercourse without a woman's consent. So that defense, this defense and the accused's perception of consent becomes completely, thoroughly irrelevant. But the court nonetheless, allows that. Now, in Mahmood Farooqi, you will also remember that in the trial court, the accused said that there was no sexual intercourse, and then changed his stance in the High Court, stating that there was sexual intercourse, but with consent. The High Court also allowed that change stance, although there were several precedents, that prohibit this. In fact, even a year before Mahmood Farooqi, there was this Raja versus State of Karnataka Supreme Court judgment, and there also the Supreme Court held that the survivor's conduct was not that of a terrified and distressed rape victim, because she had wandered around at night instead of hurrying home. And in the Tejpal judgment too, the court said that the complainant did not demonstrate any kind of normative behavior in the week of the incident. This brings me to my last point about creation of this artificial hierarchies or hierarchical categories of victim by courts in rape adjudication. So the court here fixates on the fact that the complainant knew feminist lawyers, Jayna has spoken about it, and was knowledgeable about rape laws, including the 2013 amendment, quite in the same way that in the Farooqi court fixated on the educational qualification of the victim. Now, in acquaintance rape, which is 90% of cases, courts often continue to put a very low premium on consent, and so therefore there is this need to rethink our approaches to understanding harm beyond that category of consent. There is this other issue that needs to be addressed about the trial tactics of defense lawyers in rape adjudication, and our special courts, its judges, in spite of the 2013 amendments and even the Supreme Court guidelines in the Aparna Bhatt case, which I will address later. Okay, thank you. I hope I'm in time.
Yes, Jhuma, thank you so much. In fact, your fear of the time has made you speak so fast. There was a comment saying, could you ask Jhuma to slow down a bit? Yeah. So maybe in the next round, that's probably our fault for making you rush through. Thank you for all those points you made. I think they really sort of set the frame for what this judgment is all about, and a fear that maybe this sets a precedent for what trials are going to come from now. I think that's something in our mind, which is why we've been so kind of thorough in our critique. So I'd like to move on now to Vakasha Sachdev, who's a journalist and a lawyer, and he'll be talking about the way in which evidence was appreciated, particularly the CCTV evidence. In fact, as the NWMI, we had a lot of, we intervened several times when that CCTV footage was discussed in the public domain by various publications and, digital portals. And we felt that was extremely objectionable for the media to be commenting about evidence such as that. So, Vakasha, would you like to come in on that?
Yeah, so if we look at the sort of media coverage of this also, there was, significant crazy coverage of it when it all happened at the time. I've spoken to a colleague who was involved, who was in fact on his way somewhere, and he was literally like within minutes shunted off and sent to Goa immediately to go and cover it because it was expected to be such a, such a major thing. And the way it kind of progressed at that point, I mean, when I'm looking back at least the way the reports were written, I mean, there was, I think, a sort of frenzy being created there, but there was still, there was a certain degree of responsibility to the way some of the things were being done, at least by the media. Like there was a very clear thing to, not name the complainant. And interestingly, when I've looked at some of the reports done there, there's been redactions not just of her name, but even of her partner's name and others. So which I mean, these are legal requirements. So we've actually seen the media fail to do this in many cases since then. The problems, I think, especially really started to go out of where it started to go a bit out of control towards the beginning itself was when this whole aspect of the CCTV footage came out. Now, many of you will have heard of Manu Joseph's article in Outlook, and there were other, there were a whole bunch of people who were actually commenting on what was in the CCTV footage without actually having seen it. And there were people who also had seen it, and there was no legal way in which they should have had access to that information. And the way this was reported then was, I think, quite concerning, because you had people essentially trying to say, "Oh, we've seen the CCTV footage and we think that," and it shows that what's being, what the complainant has said is completely wrong. And that's I mean, for people to have said that was significantly problematic, because there was no way the CCTV footage was ever going to show what actually happened inside the lift. I mean, when you go from there to then, for instance, later in 2018, there was then a separate push where it was again, there were angles being made, especially by Times Now, who were trying to say, "Oh, there's great dark secrets which we're going to be able to show here, and we're going to show how this completely busts open what the woman says." They had people coming on their show who were making these claims, again, without anyone actually having seen what was in the footage, and B, when it was being played on TV, also this completely violated the rights of the survivor. It violated the law which we have on all of this. So I mean, there have been instances which again show here just what is why it's so vital that we have to have a change of mindset, not just in terms of saying, "Oh, we're going to change the law every time something comes up," but really building awareness campaigns so that the media themselves also understand their role here and understand how not to sensationalize it. Because the way that whole CCTV thing was spun is almost what you see eventually later in the judgment. Because essentially the narrative being spread by Tejpal from the start has been that this is all, it's been made up. There's no actual, there's all these contradictions. There's no real basis for any of this to go forward. And in a sense, you can see that the judge seems to have almost made up her mind about that right from the start. With the way the judge kind of portrays it, it's from the start she's almost just finding every possible way to find fault with what the complainant has said. Now, this comes back to some of the points which were raised by the people earlier. If you're looking at the way the judge has arrived at, there's just so much wrong with this judgment. I mean, I don't think even if all of us talk for like an hour, we can actually cover all of the points. But some of the ways in which you can see that the judge has allowed her view to come in is in the way the language which is used, even and it was cited in the appeal before the Bombay High Court, where she talks about how, the woman, she's a yoga instructor and she should have had the strength to be able to fight him off, and she didn't. Then you come to the points later where she talks about how she was speaking to the one particular defense witness. She didn't say anything then, and how that should therefore be used as a res gestating to disbelieve her account. You see it in the way she talks about suppose the things which happened between the complainant and Robert De Niro. There's this huge section which, I mean, it's absolutely irrelevant to the actual facts of the case. And I think this is where the way the evidence was used in this case, it's just horrifying, because the judge has made so many errors with the way evidence is collected here. It's horrifying. The very fact that she allowed so much stuff about the previous relationships, the previous things to go through, even things which, as is pointed out, should have never been allowed. But this was, there was, in some cases, in some points, she's kind of said, "Oh, it's because of XYZ reason why I have to allow it." There are many parts where that's not even done. Like, there's no reasoning given for why certain things are allowed, like the De Niro thing, for instance. And what you see is this constant the judge has basically allowed a narrative to be formed, which is that this is all a fake story and it's been made up to, and then it's like she's taken the things which are brought up before her as a way to prove that point. And the level of scrutiny which you see there is so different, for instance, from the level of scrutiny used to look at Tejpal's apology. And saying that Tejpal's apology was coerced, there's no scrutiny of that claim. There's no basis actually for her to make that, to accept that argument, but it's just accepted completely on the face of it. Whereas, like other messages from the complainant, which aren't even directly concerning, like things about what her mother was doing and why she wasn't there immediately, those are subjected to an insane level of scrutiny, which disregards also the fact that you had such a long time phase between the actual filing of the complaint and the recording of evidence. So in terms of this, the big thing, which comes back to what Jayna talked about, the digital strip search. One of the interesting things is this was at the behest of the Supreme Court. The Supreme Court passed an order in 2015 saying, yes, all of this has to go through. But if we look at what it actually finally was allowing Tejpal to take control of, to get access to, was not just what was specified. Like if we look at Tejpal's actual application to the court, he wanted very specific information. And the Supreme Court actually ended up allowing cloned information which went well beyond that going to. So what we see is this situation seems to have taken place throughout the court proceedings, where the conclusion was already reached. It was reached on the basis of extremely extraneous and extremely irrelevant things, which were just never ever scrutinized. And the problem is, and the thing is, I began this by looking at the role of the media, and I think to an extent, I don't think it was the media's fault here that was done. But it's something which we have to look at, that this is how cases are going forward. So the media has to take a very proactive role in preventing these cases from being looked at in this way.
Thank you so much, Vakasha. And I think that we'll leave for the next round when we come to you in terms of what can the media actually do. Because I think this is a question in everybody's mind. If not this, then what? But I'll just go back to all the speakers again with specific questions. And Anna, for you first, I think you were really rushed through doing the critique. But, one of the questions that a lot of people ask is that, this has been like more than 7 years of a journey in pursuit of justice for the complainant from 2013 onwards, and things may or may not have gone the way in which they predictably go. For example, she did not approach the police at all. So in a way, she was sort of in the center of the storm when she had actually approached her office and attempted different kinds of redress. So I just wanted to ask you, while reading the judgment and while, writing up this critique, in your mind, what were the couple of things that, survivors actually need to keep in mind in terms of pursuing a complaint, and how to stick in there, and what does it take really to go on this journey of 7 years, which is not yet ended because there's now an appeal?
Actually, Laxmi, the thing with the reading of this judgment is that there is absolutely nothing that a survivor can do right. So the things that a survivor can keep in mind, there are no guidelines from this judgment, because everything she did was deemed wrong. And she actually followed due process to a T, when a survivor who's been through such a traumatic experience should not have to. She wrote a written complaint internally. She had to remind them that they did not have a committee in place, an internal complaints committee in place, which is 16 years after the Supreme Court gave us the Vishaka guidelines in 1997. And here is a media organization, Tehelka, that claims to uphold feminist values, and they always, at least on the face of it, had lofty ideals, but in practice, they did not have an internal complaints committee in place, and she had to remind them of this. And she's not the one who went to the police. It's because Shoma sent the third letter by Tarun Tejpal to the entire staff. And of course, it was bound to go public. And then the police in Goa took cognizance of it. So she has been put on trial for a complaint, on public trial for a complaint she made internally. And he has not been put on trial, despite the fact that there was, in a sense, a public admission of guilt, if you consider that the letter that was circulated to the staff can be deemed public. But also, what is really worrisome about this is that protections that have been written into the law for women have been used in this case to protect the man, and have also been abused in this case to humiliate and insult her. And the complete contradictions. Now, for instance, he gets to have why are in-camera trials are allowed in rape cases? To protect the privacy of the survivor. But he gets an order to allow all the entire trial to be, so including his defense, everything to be in camera. And then she is subjected to humiliating cross-questioning by the defense lawyers, and that humiliating cross-questioning is then reproduced in the judgment. And the judgment, in fact, went so far as to reveal her identity, which goes completely against the law, that you and I have to sit here and tell a judge that this goes completely against the law is terrifying for any woman who might consider also making a complaint. But also the inconsistency within the judgment. Like I pointed out earlier, the judge has conceded that there is an unequal power equation between the survivor and the accused, but then has gone on to say that it was because of pressure, etc., that he gave those apologies, or those what were deemed to not be apologies. But also in October 2019, the same judge had conceded when the survivor pointed out that the humiliating cross-questioning that she was being subjected to was in fact against the law. The judge conceded. The judge orally conceded that this is true, but that cross-questioning continued in the trial court. And then she had to, as in the survivor, had to go to the Supreme Court, had to go to the High Court of Bombay and Bombay at Goa against this hostile cross-questioning. She got a ruling against this, what the court described as extraneous and irrelevant cross-questioning, quote unquote. And despite that, and this came in December 2019, despite that, all the information that came out, the private information that came out during that cross-questioning, is reproduced in the judgment. So it's as if the law is irrelevant, and the judge's own acceptance of the existence of these laws is also irrelevant. So, personally, I've always felt that as activists, journalists, lawyers, and members of the public, we should never say a woman should do this. That word woman should always worries me, because we should be saying men should, the media should, judges should. And in this particular case, there's nothing logically that you can find in this, that even as a friend you can tell her, maybe, like, you can tell another survivor, maybe in future, maybe this is something to keep in mind, because this goes against law, it goes against common sense, it just goes against the principles of natural justice, as even a reasonable person who is not educated in the law might understand it.
Yeah, absolutely. You've hit the nail on the head. I mean, when we talk about, the reasonable person in law, it's somewhere you're looking around for this reasonable person in the law court when a judgment like this comes out.
Laxmi, can I just add one tiny point?
Yes.
Because when I was talking about the contradictions are not only within this judgment, but different courts are giving, complete. For instance, it's not that the privacy of survivors has not been taken into consideration by other courts. There have been courts that have been very sensitive to the concerns of survivors, and we know that in the case of the Kerala actor rape case, because the Dilip, who's a megastar in Malayalam cinema, is accused of being the prime conspirator in the case. And what happened was, just tiny bits of information. The person who committed the crime recorded it on his cell phone and transferred this footage to a memory card, and Dilip wanted access to that memory card. And the Kerala government strongly opposed this. He went to the Supreme Court, and the Supreme Court also rejected his request. However, the Supreme Court has not been unreasonable towards him. It has simply permitted him partial and regulated inspection of the contents of the video under conditions that would ensure the privacy of the survivor. It is not the contention of any activist that I know, not any decent lawyer that I know who is rights conscious and concerned about women's rights. It is not their contention that an accused should not get access to evidence that is relevant to him. The point is that he was given access to evidence, to things that should not have been considered evidence at all in this case, access to her private life as it had been recorded on her cell phone through personal conversations. And it is the unreasonableness of this and the conclusions then drawn from this, not just by the defense, but by the judge herself, and the completely disrespectful treatment of the survivor in this case, and the completely disrespectful descriptions of her in the judgment that are not just, it's not just about logic. As a woman, I find it outrageous and I find it heartbreaking.
Yeah, it's the same, Anna, for everyone. And I think one has just been trying to find a shred of hope, in how to move forward. And I'm going to ask Jayna to come in now and also answer a couple of questions that have come in. There's a question, Jayna, about how did the court treat the absence of the ICC in this case? Uh, that is one of the questions asked, and maybe you could take that up in your next segment, a couple of minutes, about what you were going to be talking about, sexual harassment at the workplace. There's another question I'll quickly respond from Srilata, which says, is the judgment being appealed? And yes, it is by the Goa government. Whether it goes to the Supreme Court, we don't know as yet. It's been appealed in the next level of court. So yeah, Jayna, please go ahead.
Thanks, Lakshmi. And I think it's a good point that someone raised the issue about the absence of the ICC. Now, this court hasn't really touched upon that because this is seen as a separate criminal trial, though the offense of sexual harassment 354A is also there. But I think the absence of the ICC and any finding of an ICC is an important issue that we need to raise in this case. Like I said earlier, the law, the reform in the law after 2013 provided two options for women who face sexual harassment. One is sexual harassment at the workplace. One is to go and seek a civil remedy where the standards of evidence and proof are not this high, uh, and get some remedy from your workplace, and also the obligation of the employer to address issues of sexual harassment at work. And therefore, the setting up of the ICC under the POSH Act was really to put that obligation on an employer, that it is your duty to provide a safe and equal workspace for all your employees and to ensure that there's no sexual harassment. And the criminal option is that if you do want to file a criminal complaint as well. Now, in this case, she went from pillar to post, and no ICC was set up. She didn't get any civil remedy or relief, and the police or the Goa government registered this complaint. So the court really didn't look into it at all. Um, I just argued that had there been an ICC set up, and had there been, there would be greater chances of giving a finding of sexual harassment. Probably that would have helped or assisted in, or would have been an important evidence in the criminal court. I mean, you assume that. And I just want to counter it with another recent judgment on sexual harassment that recently came out in the case of Priya Ramani. And just want to counter it in some ways that in the MJ Akbar case. Again, there was no ICC complaint filed, but when the issue of sexual harassment or the incidents against MJ Akbar were raised in the media, he filed a defamation, or he filed a criminal complaint against her for defamation. It was a criminal trial again. The court threw it out, and said that there was no defamation made out. And interestingly, I mean, though one is a positive result, and in this case it's a negative result. I think the commonalities are that whenever often when women make complaints of sexual harassment, whether criminal or civil or just in the media, they don't even go to court. Even if it's just kind of mentioned, the ones at the receiving end are always the complainants, whether it is in the form of being on trial in their criminal case like this, or being at the receiving end of a defamation trial. And it is, so the onus is really upon the survivors. In that case, Priya Ramani had to take the support of a very well-known senior advocate to defend her. Here, the survivor did not have access, or did not have she was represented by the state was a prosecuting agency, and it was and we see how this judgment came out. So, but the result is the same. You're on trial, and you are slapped with criminal charges, or made to face a trial if you raise a complaint of sexual harassment.
Yeah, so there's a follow-up question about that, Jayna. It says, as the complaint was against the employer, would it not have been made to the LCC under the POSH Act? Is my understanding correct?
Yes, yes. So if I mean the POSH Act says that you should first make it to the ICC. There should be an ICC set up. But if there was no ICC, she could have gone to the LCC. But we don't know what the circumstances were. There was great hostility from the organization. I mean, this is all from what we see in the media. And so, whether there were circumstances for her to go and file a complaint to the LCC, she could have even gone to court, to the High Court, seeking that there is no ICC set up and that should be set up. So all those options were there. I think it must have been hard for her to take up those options, or at least we don't know what her circumstances were at that stage.
Yeah, no, by which time the criminal case had been filed, actually. So as Amu herself points out, there wasn't much of a choice. She didn't really have a choice. And it did come out in the media as well that Tehelka, once the complaint came in, sort of cobbled together a inquiry committee kind of a thing. But events just kind of snowballed, and by which time the criminal case had started. So there was hardly a point going ahead with the internal inquiry. So thank you for that, Jayna. There's another question for you. Let's come back again to you for the question answer round, and let's go on to Jhuma. Jhuma, you wanted to speak about the process of lawyering itself, and there are a couple of questions to you already, which maybe you could incorporate into your next response. So one question from Carol Andrade is, given that the judge, a woman, seems to have failed the survivor so utterly, are there consequences for her? Maybe she can be advised to refresh her knowledge of the law and the need for sensitivity when handling cases like this. So this is one question to you. And another related question, there are several others we'll come back to later. But a specific one to you also, Jhuma, is what are the implications of this case? And in terms of, for survivors of sexual harassment, what do you think is going to be the implication?
Okay, I think I was planning to talk a bit about defense lawyering generally, and how the post 2013 amendment that has, we know that the Verma committee, drew up a pretty good report. It submitted a good report. Some of its suggestions, some of its recommendations, and I itemize some, were taken up and incorporated in the 2013 amendment. Many others were not part of the Verma Committee recommendations, but were what the government included. Now, so given the 2013 amendments, after the 2013 amendment, because 2013 amendment is generally considered, I mean, it has its flaws. I'm not getting into a detailed discussion of the issues, but generally speaking, the Verma Committee report, for those of in the audience who are not familiar with the Verma Committee report, is the Verma Committee was set up after the Delhi bus, gang rape incident, the Nirbhaya incident, or the Jyoti Singh Pandey gang rape case, where the victim succumbed, and after that the government there was a committee that was set up with the retired Supreme Court judge Justice Verma. Now, the committee consultative process was quite democratic. Various organizations, women's groups, not just women's groups, other groups also came before it. They submitted their suggestions, recommendations, and after a rigorous consultative process, the Verma Committee submitted its report to the government on potential amendments to criminal law, not just amendments, but also like a series of recommendations, and it emphasized on training, etc. as well. Now, after the report was submitted, there was the 2013 amendment. It happened soon thereafter. But so that was where the state's job seemingly had ended, because you have because traditionally and historically responses to these watershed moments, or these landmark I don't want to use the word landmark, but these these historical moments, they have been responded to by the state by largely reactionary responses. And I'm not going to call the Verma Committee a reactionary response, but the Verma Committee response itself was good. But what happens is eventually these kind of the work is like extremely hard. The process, the road to justice is like really hard. You cannot just make some cosmetic changes, or even changes, good changes, bad changes, whatever changes to law, and expect that everything to go like is all beautiful, and you have like a perfect justice system the next day. You need rigorous processes, you need judicial training, and not just judicial training, because when we think of judicial training and the way most judicial academies conduct training as far as gender-based laws are concerned, that is largely inadequate, because a particular judge receiving only a couple of trainings over her sort of career, her professional career as a judge, is not enough. You need trainings, you need systematic training, and it is not just training of judges. You also have to train each and every stakeholder of the criminal justice system, and that includes your police, that also includes your defense lawyers. So that brings me to the earlier question that I wanted to sort of touch upon, is that what happened here? This is not just this is not an outlier. In terms of defense lawyering in rape cases, pre 2013 amendment, this line of questioning, we have seen it largely continued post 2013. Also, these line of questioning has continued. So the question then becomes that are we training our defense lawyers about the kind of questions that are permissible to be asked before the court? We also need to obviously train our judges to who can, because judges routinely are allowing this particular line of questioning, and I have actually seen that this line of questioning is not just is not just asked or sort of used by only a handful of trial court lawyers. This actually continue across the spectrum. Big names, really well-known lawyers, defense lawyers, and they have asked really problematic questions in the courtroom. So one is the question of training. The second is that how do we then kind of correct it? So whether this particular judge, to respond to Carol's question, whether this particular judge is going to be responsible, whether there's going to be some implications. The short answer is really no. But I also want to say that why is this happening in spite of I'm not just getting into training, but in spite of a clear Supreme Court directive, we have the Aparna Bhatt judgment where the Supreme Court laid down clear guidelines. This was after the Madhya Pradesh that tying Rakhi, judgment. And in this case, in the Aparna Bhatt guideline, the Supreme Court actually ordered high courts and trial courts to not make such observations, in cases of rape and sexual assault, which tend to trivialize trauma suffered by the victim, affect their dignity and so on and so forth. And they also said that the courts should not aim at compromises, such as encouraging marriage. And you see that, you still see that, that kind of thing still happening. In fact, specifically, if I recall correctly, in the Aparna Bhatt guideline, the court had also said, in the guideline specifically mentioned that no remarks or observations should be made by a judge in the judgment which might reflect their biases, and affect the woman's dignity. And here I want to take you back to I think this is para 23 of the, I'll just conclude para 23 of the judgment in Tarun Tejpal, where the court actually observes that with the help of experts, there may be a possibility of doctoring, of events, etc., and adding of incidents. So basically, what the court is, it's not even an insinuation; it's a direct, it's an accusation. The court is stating that the victim knew feminist lawyers, prominent women's rights advocates. The women knew, the state women's commission members. The women knew, the complainant knew personally, knew new NGOs and other organizations, and therefore there is a possibility of fabricating of evidence. And actually, that is, if one really looks at that 500 odd page of judgment, that is really the core, the crux of this this judicial, this judicial disbelief. The court tends to disbelieve because in the next 500 odd pages, what the court does is it continues with that scrutiny and then castigates the victim for minor omissions and then omissions and discrepancies by stating, what it states is that the same is not keeping with her. I think in one part of the judgment, it says that with her highly convenient memory, which fails to function at crucial times, whenever evidence to the contrary is produced. It says something like that. So that means that the court, forget even the Aparna Bhatt, the guideline, the court is actually tossing out decades of jurisprudence of rape law about minor contradictions and omissions. And then it goes, so this entire, the next 500, after the para 23, the next 500 odd page is basically the court giving credence to that, to that disbelief, that it really doesn't believe what the victim has been saying.
Thanks, Jhuma. And I think this points to what some people have been commenting also. I think it was Amu, about the need for training of judges and the judiciary. And I think Naina Kapoor and Jasjeet, in the 90s used to be conducting trainings with judges about, just examining patriarchy and so on. And in fact, I think gender is one of the subjects in judicial academies where they look at, but it just shows us the limits of training, I guess, when biases and prejudices are so deep and ingrained that it would need more than a training course, I guess. And it's, sorry, you want to say something?
Yeah, I just wanted to address just like one point I wanted to make is that, see, this is also happening in a special court, and you would expect that a special court judge is trained, what is the purpose of a special court? So, we also need to ask that what is really happening in the special courts. There needs to be some systematic audit. We need to find out that what is exactly happening. Are the judges, are the prosecutors, they're trained? Are the judges being trained? Are there even defense lawyers who are appearing there? Are they trained? So training, I really think that we need to sort of rethink how training happens, because traditionally what happens is that the judicial academies do trainings, and the trainings are traditionally done by judges. You really need to involve civil society actors, other actors into that training process, and training cannot just happen only of judges. There needs to be, judges, all stakeholders should come together and be trained. So there should be police, there should be judges, and judges at all levels. It's not just enough to say that we are training trial court judges and we do not need to train high court judges because high court judges know everything, or Supreme Court judges for that matter. Training at all level needs to take place. I'll stop there.
Yeah, absolutely. And even of the police force, actually, in the 80s and 90s, there used to be a lot of engagement with law enforcement to just look at sexism even within the police force, because a lot of the lapses which have happened in this have been during the forensic stage, evidence gathering stage, and so on by the police. So we're not focusing as much on that, but there has been huge gaps there as well. So we'll move on to Vakasha for your last round of comments. I mean, of course, before the question totally opens up. But there is a question for you which you could probably incorporate into your response. So Varun Anand asks, what training do reporters receive to report on cases of sexual assault or rape? For example, not naming the survivors. Where do the guidelines come from and how are they implemented?
So I think yes, I can quickly pick that up to start with. The sad fact is that it's pretty much ad hoc. There's no, real training which is guaranteed to be there for every single reporter. Now, I mean, those who are obviously going to be studying journalism, there will be parts of the course where that will be discussed. If you're a lawyer, then again you will have come to it with some sort of knowledge as well. But the problem is that actually when we look at news organizations, there needs to be more done. And it was this was something which when I joined the Quint, for instance, we there was a set of editorial guidelines and there were things which talked about this, but we started doing a bit more, with that, with actually having a lot more discussion about all of this, with having sort of workshops for people, and then also, discussing these legal nitty-gritties and sending out additional information on it. Because, it's what happens sometimes is if there isn't enough discussion and understanding of it, then there are things which can slip under the radar. So one of the easiest things is, what happens in a case involving a child, or where the child's, for instance, gone public. So if you remember, there was a case with that girl who'd acted in the wrestling movie, and she'd herself come out with the story. But then the question was, should media organizations put her name, put her photo, put any of that out there when the person when the person herself had come forward? Or you had the Kathua rape case where where the victim is dead now. And in those cases, what should happen? Now these are senior people might have an understanding of it, but a junior reporter working on desk or someone having to get a story out may not fully understand that. So I think it's a matter of having sound editorial guidelines and workshops and training which can cover these aspects and explain to people everything. Say that, okay, look at section 228A of the IPC. That's what says that you don't disclose the name of the complainant in a rape case. You take them to the POXO Act and to the provisions there which talk about media. And why I'm saying that actually it's important to really go through the law than just say, okay, you don't do this, is because there's an understanding. Because once you do that, then you can start to actually ask questions about why that's the case, right? So for instance, especially with POXO, for instance, you understand that it's not just about don't put a name and don't put a photograph. It's don't show the locality, don't show anything which connects them, connects the family, don't show anything which can really be used to identify the person, which isn't even directly identifying it. And the understanding, then you get the idea that it's a matter of privacy. You get the idea that it's a matter of not allowing that intrusion. And then that it opens up the further questions as well about why is it that about the fact that we have this kind of intrusive way of going after people, going after almost the survivors in these cases, and the victims in these cases. Just sort of coming back to something which was being discussed earlier, which was the question of training. I mean, since we're talking about it in terms of journalists, and I think organizations like the NWMI can perhaps take on a greater role in this as well. I think all journalistic organizations have to do it themselves, and then having a broader sort of organization looking at doing that training for media persons, or giving sort of basic kits and guidelines and things which can be followed and made part of an orientation program. I think these are all things which can be done on the reporting side. On the side of the judges, I mean, one of the things is that I think there's an urgent need to kind of really think very carefully about how we're doing these kind of reforms. And this is touched upon earlier as well, is that, look, 2013, you had this come up. It's, you have a set of recommendations from the Verma committee. Not all of those come through in the law. The point is, every time we are looking at reforms these days, it tends to be very knee-jerk reactions. There's not a lot of thought of the bigger picture issues behind all of this. And that's why, you'll have, you can say a woman judge and then you have a woman judge giving this. You can say have a fast track trial court and it still takes 7 years for the case to be heard. The question of reform, I think, has to be done much more carefully when we're proceeding this, rather than just kind of having knee-jerk legislation, because that's when you start to ask yourself, okay, how do you then make sure that you don't arrive at a judgment like this? Because this judgment, there's just, the fact, some of the things here are so chilling, like saying that, the fact that the woman's gone and spoken to a lawyer, to feminist lawyers, is therefore potentially grounds for tutoring. I mean, that's just, it's scary that that's something which a judge is going to feel. Now, the good news is obviously that at least those aspects of the judgment will get knocked out on appeal. But the point is that doesn't necessarily take away what the survivors don't have to go through. In every one of these cases, if it gets changed on appeal, it still doesn't change the trauma which the survivors would have to go through in each of these circumstances. So what it points to is the fact that there isn't a consistency with any of this. And no matter how many times you'll have the Supreme Court putting out an Aparna style guidelines, or no matter how many times you have going forward, you need to have a greater degree of consistency with what's done. Now, so I believe Geeta Mittal, for whatever other things one might argue with the way she went about the courts, especially in Jammu and Kashmir, but in Delhi, for instance, she had a very strong program for training judges in Delhi on this. And the consequences are that one of the things, which is that when you have these evidence-based kind of these character-based assassinations being done, is that a judge has to at that point itself cut it off and say no. Now in Delhi, to an extent, that is happening now. That when these irrelevant questions are being used, at that stage itself, the judge cuts it off. But in many other places, and as we saw here, the judge allows them to be made, and then they'll say, okay, later I'll look at the question of admissibility. But the problem is, the moment those questions are allowed at that stage, it's then creating a bias in the judge's mind. That's what I feel is what we see here. Like, the judge has made up her mind on the basis of several biases. So what you've got to look at is having, not just the Supreme Court get involved with this. There has to be, I think what Jhuma said about having a multi-stakeholder approach to creating these kind of awareness and training programs is crucial, because if that's not there, you will keep having to plug holes in the process as it goes forward, no matter what you have, because the trial judges are being influenced by these other factors. Now, and I think, in terms of this is, again, as I said, perhaps a place where the media can come in, because we can start building this narrative about understanding that the judges have to have a better understanding of these issues as a whole. And that's going to come the more we do the training within our own organizations, the more awareness we create within our own organizations. That will help drive those conversations. So, I mean, it's great that we're having this conversation here, and, because these are the kind of things which we have to then take forward to actually, like, trying to build, targeted programs to improve that.
Yeah, thanks, Vakasha, and thanks for plugging NWMI. We are happy to come and train whoever wants to be trained. In fact, the Bombay chapter has been doing some of the training with some media houses in Bombay, and it's just a very small drop, but we can talk about how this could be, maybe replicated to actually make a difference. So there are actually plenty of questions, and we have, I think, 13 minutes left, actually. I don't know how strict BIC is about the time, but maybe we could take 3 or 4 questions. So I'll try and club some of them together and see how many we can respond to. So Amu asks, anyone can answer this. How much influence will this trial court judgment have on future cases of sexual harassment, assault that go to court? If the appeal that has already been filed by the Goa government is successful, what happens to the legitimacy of the highly problematic trial court judgment? What happens if it is not successful? That is the appeal. Is there any room for a higher court to rule that it should not serve as a precedent that other judges can use in future? And she has a related question. What impact could the fact that the legal provision for in-camera trials in cases of sexual violence was used in this case by the accused to prevent the media or any other external actor from witnessing what was going on? So who would like to take this question? One is the implications if the appeal does go through, the implications if it does not, and what happens to the trial court judgment?
No, I mean, I'm happy to take it up, but if someone else, Vakasha or Jhuma or Anna, want to answer as
Uh, you go ahead. They can maybe add a point if
I'll just
they'd like
talk
to.
at least
Yeah.
about the first thing that the trial, it's in appeal. And if it all depends on what is the, what the High Court, right now it's at the High Court. So, what the High Court rules, and then thereafter, if it does go to the Supreme Court by either party, and it will, it depends on what the High Court rules. If it sets it aside, then obviously this judgment is gone and will have no impact. And so that's on that. On the in camera proceeding, it's an interesting question because, um, you know, the idea behind it to really, though it's unwritten, we have in camera, procedures in any trial. It's usually to protect women from, being in a crowded room and kind of, answering questions on certain issues in a private space. But it can be used by either party. It certainly can also be used by an accused as well. It's not limited to just a survivor of sexual assault or complainant or anyone else. So it can be used by any party. And yes, that will impact media coverage, but we've also seen that where there is no in camera trial, accused persons have actually sought for media gag orders. So, whether you get it this way or that way, courts are quite happy to give media gag orders to ensure that media doesn't cover it. So, yeah, that's a big issue.
Yeah. Okay. The next question from Namita, who says this is not a question, but even as the term digital strip search seems like an effective term, it may not be the appropriate one or sensitive. And her question is, does the right to privacy not provide any protection to the prosecutrix in this judgment, or even in the future in other sexual assault cases, where similarly WhatsApp messages and other uh, uh, no, sorry, it takes, I'm sorry, this is gone. Go ahead. It's basically about privacy and WhatsApp messages and other forms of digital evidence of such a huge volume can be made available to the accused or the defense. And so any of you can answer that. And Geeta Seshu has a specific question related to Jayna. WhatsApp messages are not allowed as evidence, and the recent order also says so. So can't the police be directed to desist from using WhatsApp messages?
Now, would you like to go first and then I follow with that? Uh, I just saw Anna and Vakasha
Yeah,
also unmute themselves, so I'm happy to go after them.
yeah. Anna?
No, actually, there's something else I want to speak about. So why Jhuma and Jayna can talk about this, and then I'll come in.
Okay.
Um, yeah.
So to just confirm, there's two parts to it, right? One is, does the right to privacy offer any sort of options here for the for a survivor in a case like this to prevent this from happening? And two is, what is really the value of WhatsApp messages here, and should they not have been useful at all? I think the thing is, the right to privacy angle is crucial because, especially as I mentioned earlier, it was never even requested at the start that this extent of information be given to Tejpal. Tejpal himself, his request was actually for messages from 7th November to 31st December 2013, nothing else. That was his own application. The problem is that this points to a bigger issue with digital cloning, which takes place in cases constantly, where everything else is provided. Now, the right to privacy judgment should actually prevent this, because if you look at the proportionality test, it should limit what is being asked for, what is provided. Even if the accused may ask for a lot more, the court itself, when ordering certain things to be given and taken, should be putting an imposition, in terms of proportionality there. I mean, that's something which will have to go forward in, it'll require, I think, more litigation going forward, because till now there's really not been a consideration of that, and there is very little consideration of that in general with the way digital cloning takes place. Even what you can see in the Delhi riots cases, where just everything is sort of being picked up and then being used against the person. But that's something which has to take place in the course. So the WhatsApp thing, it's a bit trickier because obviously the messages will not necessarily be used as proof of anything as a whole, but even the limited usage which can be done is itself can be quite damaging if the judge isn't careful, as we saw here. The judge doesn't stop the line of questioning once it goes beyond something. If you've been allowed to access things which have no connection to the actual case, the damage is already done, even if it's not held to have specific evidentiary value. So that's something which actually has to be nipped in the bud even further, and that's one of the takeaways you have to look at, I think.
Yeah, Jayna, do you want to add to this?
No, just want to clarify that actually there's no bar against use of WhatsApp messages as evidence. It's been used in courts everywhere, so there is really no bar. And now when we're seeing with this whole kind of spyware and surveillance being done, it's builds the the access to that, and that's actually something we should be really be afraid of how far it can go. And again, just to supplement what Vakasha said, that right to privacy and the limiting how much is made available of the digital material. But I think it also raises the question, the dangers from this judgment, that do our prosecuting agencies, do our police actually even have the technical ability and wherewithal to actually limit this kind of digital access? Because if someone asks for the data from this date to that date, you should have the resources to actually take that out. And I think what happens is that it's just easier to give the entire phone records, and then privacy and none of that is kind of it's all thrown out of the window. And part of it really is that you need now prosecuting agencies, investigating agencies need resources, people, money, and time to ensure that as more and more digital material is available, to actually sift through and kind of not just use and make available only what is relevant and not anything else.
Anna, you wanted to add to this?
Actually, I wanted to connect something that Vakasha had said earlier about how many of the things that got discussed in the media then ultimately got reflected in the judgment. And Jhuma had also spoken about the sensitization and training of all stakeholders involved. And I think in a case like this, the definition of stakeholders, and actually in cases of sexual violence, but also in many other cases related to social and political issues, the definition of stakeholders has to be expanded, because what we saw discussed in the media and what we saw discussed on the social media also we find being reflected in the judgment. And what we saw discussed in the media came from people who were not all, they were not necessarily lawyers or, members of investigating agencies. And I'm going to bring in a point that you probably wouldn't expect in a discussion on law, but around that time, I had interviewed Anurag Kashyap, the filmmaker. And as you know, one of Tarun Tejpal's daughters works in the film industry. And I'm not connecting the two, but he had said some very, very disparaging things in my interview about the survivor in this case. And he said that she did not display the body language and behavior of a survivor of sexual violence. I'm not quoting his exact words, but this was the gist of it. And we find pretty much the same thing being, being said in the judgment, that the survivor did not display the normative behavior of a survivor of sexual assault. So the training has to go beyond, apart from the understanding of the law, which is shockingly inadequate, as we can see in this judgment, but the psychology of victims of violence is something that needs to be constantly discussed, not just among those who are traditionally and conventionally considered stakeholders in this whole legal and judicial process, but in the public realm too, because it is actually, it is not an exaggeration to say that the general public seems to continue to believe that if a woman is sexually assaulted, then the quote unquote normal woman would come running out of a room with hair disheveled, cuts all over the body and bruises and screaming, "Bachao, bachao." This, it might sound silly, but it is exactly and precisely what large sections of the public and highly educated people, from whom you would expect a greater understanding of the body language of victims of sexual assault, large sections of the public and such people display this ignorance of psychology. And they end up, I mean, someone like Anurag Kashyap that I'm referring to is someone who has made films. And I was speaking to him at that point. The reason why this case came up was because I was speaking to him about how he had so beautifully conveyed in a short scene in one of his films the manner in which a woman is assaulted and gathers herself and collects herself within seconds and then moves ahead as though nothing had happened. And I was just telling him how wonderful that scene is and what a contradiction it is to his public remarks about the survivor in the Tarun Tejpal case. In addition, and I want to connect this to something that someone who's listening to our discussion has just written to me on Twitter. He claims to be a lawyer in the Bombay High Court, and he has just written two words: capital punishment. You see, all this tokenism and this cry for capital punishment. Every time there's a major high profile case, immediately you have in the public, you have people saying, A, capital punishment, death to the rapist; B, increase the punishment; C, okay, so what is the point of all of this if even the fact that, like Vakasha pointed out, we have a woman judge here, it's a fast track court, and this is coming under new reformed laws. All of this has made no difference. So in addition to what was pointed out by Jhuma about the sensitization of everyone involved in the legal and judicial proceedings and the investigating agencies, I think that we have to look at an even larger picture, however exasperatingly long-term it might be, and we have to talk about how we need sensitization and gender sensitization of children from the junior school stage, so that they understand the meaning of consent, the harm that gender segregation is doing in our society, and as they grow older, to understand the meaning of sexual assault and to understand how survivors of sexual assault respond, and that there is no such thing as a normal, quote unquote, survivor of sexual assault, because the conversations, for better or for worse, the fact is, the truth is, the conversations in the public and in drawing rooms and on social media and in the mainstream media are getting reflected in the judicial pronouncements that we are seeing.
Yeah, no, absolutely, Anna. And I'd like to actually respond to many points you made, but we've already run out of time. And Lekha tells me that we can have 5 minutes more. So it's just a couple of very quick questions. And if any of you can volunteer to answer very, very quickly, then we could maybe take up two, otherwise just one. So one of the questions is from Mohan Rao. Would anyone like to comment on the revelations of the Pegasus taping of the complainant against the Chief Justice of India? Was this to blackmail the Chief Justice of India to give favorable judgments as he has? Anyone like to answer that very, very quickly? A lot of smiles.
I think everyone's
that
smiling.
The answer?
No, I think everyone's smiling because obviously we cannot respond to that with any degree of clarity. However, I want to call out India's liberals on this point. And this connects again to the point I made about that Jhuma made earlier and that I made about sensitization and education of the public. At the time that these revelations, at the time that this woman's revelations first came into the public realm, Gogoi was a darling of the Indian liberal public. Subsequently, he fell out of grace because of the various things that he did. Therefore, at the time that these revelations came out, there were large sections of the Indian liberal public that condemned this woman and said that she had been set up by the government. And you can see these conversations on the social media, that she had been set up by the government to discredit Gogoi because he was one of the judges who was part of that press conference that spoke out, right? And the same members of the Indian public have now changed their minds about this woman because Gogoi has fallen out of favor with Indian liberals. But the woman in this case has been irrelevant to them. The woman's statement was credible and consistent, and it was reported fully in its entirety by some wonderful journalists. And the contents of a statement should have been the only thing that the public should have been looking at when forming any opinion. I mean, because opinions are inevitable, but the public allowed extraneous factors to come into play. So this education and sensitization has to be not just about the law and about psychology, but about introspection about our own prejudices when we, as members of the public, respond to women complainants in sexual assault cases.
Yeah, so I'm going to just quickly run through a couple of questions just because there have been so many fantastic questions. I don't want to miss so many out. So Saloni Ambasta says, how can the common person be made to understand the problems with this judgment, given that judge's word is taken as gospel in this country? Avantika Mehta asks, one thing I noticed during my time reporting in fast track courts is that the judges get more cynical over the years for whatever reason. They're usually in the courts for years. Are fast track courts and lack of rules around a judge's time in court failing survivors? Avantika also asks, can we get some clarity on how the recent judgment on right to be forgotten impacts cases such as these? Very quickly, because we're already over the 5 minutes. So in 1 minute, if any of you could just touch upon the legal implication of the right to be forgotten. That was one. And a comment about fast track courts, which I think Jayna or Jhuma, I think one of you already commented. Jhuma, do you want to take this question?
Jhuma, you've muted yourself.
Oh, sorry. The question, I'll take the question about, there were two questions that I wanted to respond to. First is the earlier one, the earlier one about the Pegasus leak and all that. And I just want to, it's difficult to not respond to this question. And I just want to, piggyback on Anna's comment and say that at the very least, we need two reports to be made public. One is the Justice Patnaik's report on the claim of supposed conspiracy, which was brought before the Supreme Court by an advocate of the Punjab and Haryana High Court, and subsequently after that there was the committee was set up. One is that report, and the other is the report of the committee itself, which was later led by Justice Bobde. So we need to have these two reports out in the public, given in any case, we are entitled to those it's the public documents, but now that new information has come out in the open in the light of Pegasus, we really need to make a demand for making those two reports public. And there was another question about how can the common man be made to understand the problems with this judgment, given that the judges' words are taken as gospel in this country. And I think that's what we are trying to do. We have to relentlessly, no one is, no one's word, no one is God, no one is beyond critique. Institutions, do not just, pander, do not just like hand out, gospel truth. So, we have to constantly critique publicly, social media, wherever, about problematic and difficult judgments like this. And there was the other question about, what was the question about fast track courts? I forgot, but maybe Jayna can respond to
that. Do judges get cynical with
I have seen, I've done a fair bit of interview of judges, spoken to judges in trial courts, and I can't say with certainty whether they usually get cynical over time, but judges also tend to be judgmental. They prejudge at times, and no judge is, no two judges are the same, and no case is, no two cases are, are exactly the same. So judges do get cynical, but the thing is, we have to. This is partially where trainings also come into, I mean, I'm not saying this about gender sensitization and all that kind of training, but generally trainings in general, judicial trainings, the job of judge, I mean, the judges have a duty to not be cynical, and the judges owe it to themselves and owe it to the general public at large.
Yeah, Jayna, you want to respond to that? Or
No, I mean, I think she's covered it. I can only say that often you find in special fast track courts, we've seen in a lot of, the special courts under the SC/ST Act, the special sexual assault cases, judges, not just judges, but also public prosecutors tend to be a little judgmental. And the trainings have to kind of dislodge this kind of common narrative of misuse and she consented. And, these are common things which have to be dislodged. The only last point is that how do you make common people understand judgments like these? And while we can't address many of these trial court judgments, one thing what the CLPR has done is we've set up the Supreme Court Observer. It's a web portal where we try and write plain English write-ups or easy to understand summaries of important judgments of the Supreme Court which have a public impact and which non-lawyers and members of the public would like to understand. So it will, but maybe important judgments of the trial court like these also should be done. But do look at the Supreme Court Observer. Thank you.
I'll just
And
have one
Lakshmi,
very.
of course.
Oh, sorry.
sorry.
Sorry,
Yeah.
can I be
I
heard?
was just going to. I was just saying there was,
Vakasha, yeah.
Lakshmi, of
Yeah.
course. Oh,
Vakasha
sorry,
is just saying
Yeah,
something.
Vakasha,
Yeah.
there was a quick thing which I wanted to point out. So we are kind of lucky that we do now have a good focus on the legal sphere in India. We have dedicated legal news portals. We have resources like the Supreme Court Observer, and we have an understanding, I think, that we have to start critiquing more. And I think that's something which we need to do more and more for judgments on a regular, everyday basis. And I think that's happening. So we are seeing that take place now in India. There is an understanding of the fallibility of the judiciary. But, and this is the last one I just want to make, is that this is tied to both that, like having an understanding of that for the public and for all of us, and also for addressing things like what we saw with the Pegasus revelations about Gogoi, is that has to be an institutional level change. The thing is, the big failing of the Gogoi case was what we found. We saw that the Supreme Court Chief Justice gets to decide everything, even if the allegations are against them. That cannot be the case in an organization which is supposed to be upholding the highest standards of liberty, of highest standards of justice. That cannot be, that goes against what is there in the the 2013 Prevention Sexual Harassment Act. It goes against the Vishaka judgment itself. So the fact that those things are still not being addressed. In 2014, you had Nariman and PP Rao had been appointed as amicus to look into whether what the process should be, and they had pointed out all these flaws. None of these were taken into consideration for 7 years. And that's what then allows you to then have Gogoi sitting on his own bench and defending himself and using all the stereotypes. And if that's the case, that's going to make it really hard to kind of fight against these stereotypes if you have the Chief Justice of India defending allegations against himself, using his pulpit as a judge, to you, and using all the stereotypes. So that kind of institutional action has to take place there. Otherwise, that will then help also percolate all these points further down to trial courts as well, which is a long process, and as Anna pointed out, is a societal process as well. But it has to be some urgent actions taken at the top at an institutional level.
Okay, I'm sorry, but we do need to close. We've already gone 10 minutes over. Maybe you can write to the panelists. Some of the questions are really interesting. For example, if someone were to make an work of art or write a play about this case, would they get into trouble because it's under appeal? So maybe you can just say a yes or no for this question. Would they get into trouble writing a play, for example, about this, or making a film about this case since it's under appeal?
Jayna, Jhuma.
Yes, no, that's all, because we've really got to wrap up. They would. Okay, yeah, they'd get into trouble. So don't do that. You can change the names of everyone and get through those. This is a work of fiction story because it actually sounds so incredible. It could well pass as a work of fiction, So I'm sorry really to cut you all off. I'm sure we could sit here another hour and go into so many incredible points that you've all raised. And the questions from the audience have also been really, really interesting. and apologies to have to cut it off here, but I'll hand over now to Lekha. Thank you. I think this really, maybe we could continue this conversation, maybe over mail or in some other forum, because I think so many issues have been raised that they cannot be dropped at the close of the session. So thank you, all of you. Really, big thanks to you.
Thank you.
I think I speak
Thank
for
you.
the citizenry when I say this has been a deeply troubling, in a long list of troubling events that we've been all witness to. Thank you, Anna, Jayna, Jhuma, Vakasha, for your time and your insightful articulation of the matter at hand, which keeps recurring in different forms and different names. Thank you, Lakshmi, for your expertly paced moderation. Thank you, Network of Women in Media India and Center for Language and Policy Research for giving us this conversation. Thank you, everyone in the audience, for being here and engaging with the panel. All I have to say now is good night, everyone, and see you next time.